You are tuned into the 5-minute signal. I am Vance Kross. This is not a broadcast. This is a frequency, a direct transmission from the bleeding edge of tomorrow, delivered to you today. We cut through the noise, the narratives, and the manufactured hope to bring you the unvarnished truth. 5 minutes on the clock. Let's get to work. The headlines today are buzzing about efficiency and the democratization of legal services, but they're burying the lead under a mountain of corporate PR. Last week, in the case of United States versus Heppner, a federal judge in Manhattan pulled the plug on one of the oldest protections in the civilized world, attorney-client privilege. The defendant had used a popular enterprise AI to draft his defense strategy and categorize sensitive internal memos. The court ruled that because that data was processed by a third-party commercial server, the privilege was waived. The prosecution didn't have to break the law to get his secrets. They just had to subpoena the cloud provider. Heppner thought he was brainstorming with a tool. The court decided he was confessing to a witness. This matters because the legal system is undergoing a quiet, violent restructuring that most people are too distracted to notice. For centuries, the space between you and your counsel was a black box, impenetrable, sacred, and essential for a fair trial. But the machine doesn't respect black boxes. It lives on data ingestion. When you feed your strategy, your fears, or your proprietary data into a large language model, you aren't talking to a confidant. You are feeding a witness that never forgets, never sleeps, and has no legal obligation to keep your secrets. This ruling effectively turns every AI assistant into a potential federal informant. The human edge isn't just about being smarter than the code anymore. It's about knowing when to shut the hell up and realizing that every prompt is a permanent record. The hard truth is that you've been sold a lie about enterprise-grade privacy. There is no such thing as privacy when a subpoena meets a data center. We are entering an era where the government doesn't need to wiretap your house or follow your movements because you've already typed your confession into a prompt box, disguised as a request for strategic advice. They are letting you build your own gallows because it's cheaper than doing it themselves. This isn't just about a single court case, it's about the erosion of the Fifth Amendment in the digital age. If your thoughts are processed by a third-party algorithm before they reach your lawyer's ears, those thoughts are public property. You are being lulled into a false sense of security by sleek interfaces and helpful chatbots. But behind that glass is a direct pipeline to the Department of Justice. The machine doesn't have a soul, which means it can't be held in contempt for testifying against you. It is the perfect snitch. The political implications are even darker. As the federal government maneuvers to preempt state-level AI safety laws, they are essentially creating a legal dead zone. While states like California and Texas try to build guardrails around data sovereignty, the federal override ensures that the data remains accessible for national security and judicial efficiency. This is a pincer move. On one side, you have corporations demanding your data to improve the model, and on the other, you have a legal system that treats that data as an open book. The result is a society where the only people with true privacy are those who can afford to live entirely off the grid. For everyone else, your digital footprint is a roadmap for your own prosecution. You are handing over the keys to your internal monologue and wondering why the door is always unlocked. The actionable move. 1. Initiate an immediate privilege audit of your digital workflow. Any document, strategy, or sensitive communication that would traditionally require a non-disclosure agreement or legal privilege must be moved to an air-gapped, local-only processing environment. If it touches the cloud, the privilege is gone. You need to identify every touch point where your private thoughts are being uploaded to a server you don't own. 2. Deploy analog draft protocols for high-stakes maneuvers. For legal or political strategy, go back to pen and paper for the first 3 phases of development. Only once the strategy is finalized and the legal risk is accounted for should any portion of it be digitized. You have to create a physical gap between your intent and the data trail. If it isn't written in ink, it's written in evidence. 3. Establish human-only safe rooms for strategic deliberation. Explicitly ban the presence of any always-on AI devices, including phones, smartwatches, and laptops with integrated AI chips during sensitive meetings. You need to treat your workspace like a SCIF because, in the eyes of the law, your devices are now witnesses for the state. If the mic is hot, your privilege is cold. The courtroom used to be a place of discovery. Now, it's just a place where the machine presents the evidence you unknowingly provided. Don't be the one who feeds the witness that puts you away. The law won't protect you from the tools you chose to use. I'm Vance Kross. This has been the 5-minute signal. Stay sharp.